Either one, see, father, mother, either one only. Either one only. That level they are fair enough only. See, first of all, we have to understand one logic. If somebody can't be there without father, correct? I don't understand the logic of they're putting father or mother. Okay, even father expired also, must be somebody must be there also. Whether he is in this planet or somewhere in the heaven also, his name is there in the world. So still they don't want to take a chance, mother name we have to put. And suppose you don't want to put your mother, you feel your wife or husband is so close to you, then you can spare those name and put a spouse name. And nationality, place of birth and date of birth, district, state and all we have to give now. Occupation and PAN number and permanent residential address, this only I told. And also present address. So both we have to give, and we used to that, already it is there, but this 1 year period is a new requirement now. Okay. Now that list continues, that subscriber list. In fact, more than our horoscope, this only is going to tell everything. Somebody in future going to see any bridegroom, they need not to see the horoscope. They can go and verify in the ROC. It carries everything, no? Even spouse is there also, it will reveal. By mistake he will put, you may not think that they will go and verify there. Okay. Email ID of subscriber, mobile number of subscriber, phone, fax number, fax, that and all gone long back, I don't know, except government department, nobody else is using fax, I believe. Okay. Proof of identity, residential proof, proof of nationality in case of subject is a foreign national. And each survivor to the MOA shall furnish specimen signature. Thank God, the draft rule, if you would have seen, it was asking only the bank's authorization of the specimen signature. See, then how many people, you could have formed the company then. As it is, our business people now running behind the bank to get the signature in IE code form. That itself, as if like a president signing, president of a country is signing, the banks are, taking that level details from the promoters and entrepreneur and signing, and they take 1 week or 10 days time to sign and give the form in IE code form where they require the special signature of the bank. Now for just incorporating a company, in fact in US they in a system they do in a 2 hours time, incorporation of company in United States. But here where the country where we are living, already it was so simple only. In fact, with a lot of other, for the difficulties we form in a week's time, we form a company. But the procedure was simple only, not cumbersome. Of course, officials make it cumbersome, that's different. Now procedure itself is cumbersome. And see that once procedure becomes cumbersome, an official will become still more cumbersome. They will say that no, you are not followed this. See, they are asking fax number, why you are not put? You can't show that, no, it's option only, it's not written optional. It says fax number. He will say, no, it is there, no, then you have to put some number in that. And you have to borrow fax number from some other office and put only. So then they will say fraud. That you have to be very careful. That's why I'm doing in everything. That's why I told you it's become a policy law. You can't interpret it and say logically and reasonably, no, this only appears right to me. No, it appears right to you, but you follow this. This is the law. It may be right to you, but this is the law which you have to follow. And now, fortunately, now they add in the final rule. It's missed out in the PPT. Either the bank attestation can be taken or notary public. In fact, either they prescribe that limit which is so difficult to get, or notary public which everybody get. Okay, more than person putting his signature, he get very easily notary public signature. That level they made so easy nowadays. But good thing, of course, we have to appreciate, we should not talk anything. Then immediately somewhere he will get the information, remove, tomorrow notification will come. Now Ministry has decided to done away with the notary signature. Then again we have to run behind the bank only. Without incorporating company, we have to ask bank to certify. I really don't understand how it will happen. IE code also I can understand where company is already in existence and somewhere the bank account should be there and he can get the signature. How could before I form a company I can take a signature, then I have to take my saving bank. Then I have to compulsorily have a bank account. Not only the PAN, bank account also I should have then. I should have money also with me or what. Otherwise I should not live in the country. Fine. And yeah. Yeah, subscribe only. Yeah, that's what I'm telling. Then without bank account I can't do anything. That's what we are trying to say. I can't keep money 3-4 lakhs at my home without opening bank account. I can't live. I can't give a company 50,000 cash and become a shareholder. Anything is prohibiting in the country, nothing. So I can still live without bank account, right? Anyway, but I am just telling the logic. They of course now they are given opportunity of notary public. That's okay, but in the draft rule, see, attestation of bank alone was there. Now they would have thought that okay, enough we crucified the corporate and professional. Let us little give some question to them. And if the subscriber is already a director, then again the list is we are going to give, and which the list that we used to give under section 304 and 305 of the old act, the same list we are going to give at the incorporation stage itself. And the procedure, that is a big thing they have put. In fact, one thing we have to appreciate. Now, whatever they thought, even single instance also, they have tried to include in the act. In fact, that level we have to appreciate only, that level they thought of. Even one single scam only completely turned our civil act into the criminal act. Now the present act became completely criminal side, okay, because of the one scam, major scam. So like that, one incident is enough for the government to think and bring into the act. That means they are not taking any percentage of possibilities or percentage of compliance or percentage of difficulty. If one case is there, that is enough for them. Immediately they bring into the law. Like this, there are so many references that we can give under the new act where one fellow would have got struggled, one fellow would have failed. Immediately it becomes the law for the whole country. That fellow failed, then everybody will fail, then let me bring into the law and make entire population in 110 crores or 20 crores population to follow that. So I think ministry approach is going like this just for the reason that people are taking advantage. Business community is taking advantage in the country. That's the reason they thought okay, let us put. Now they put illiterate. The rule is very clear, and how the memorandum should be signed by the illiterate and other fellow. Okay, illiterate, literate. Okay, we can make it like this. How the signature has to be made by the illiterate, how the signature has to be made by the literate. And in fact, we used to incorporate a company with the illiterate people. In fact, I have 2-3 this thing I myself have done, where they used to do some handicrafts kind of thing, and they want to do in a bigger level. They said signature also they are not capable of putting. With the thumb impression, we incorporated company. It happens, and government would have thought that okay, it's good to come out with that also, so make it very clear. So there is a provision, if illiterate who can't even know to sign, then they can incorporate a company, but the person who is witnessing, he has to sign, and he has to give a declaration saying that I made that person to understand what is there. And in fact, he also should say that I am taking the responsibility that he has understood. So that level they are taking a declaration now for subscriber, illiterate subscriber, but literate we see now. If the subscriber is literate and individual, the name, address, description, occupation in the presence of at least one witness. So here again confusion is going to come. In future we have to wait and see going forward what the authority is going to insist us. Generally what happens when subscriber signs, if 3 subscribers are signing, one witness will be put. Okay, and we say that in front of me all these people have signed. Suppose in various places, then that signature has to be witnessed by a person who is there along with them or that same city or country. And now if we really don't not able to understand, we don't know what the regulator going to say. Now they made it very clear, name, address, description in the presence of one witness. Whether that one witness can also be witness of other subscriber, that we have to wait and see. And witness and sign along with the name, description, occupation, that's usual. And this is a declaration that witness has to say it. Okay, what is the declaration? I witness to subscriber who have subscribed, probably have is there, then they may be permitting, they are supposed to permit. That interpretation we can take. And signed in my presence, further I have verified is their ID for identification and satisfied myself. The same thing we are giving to DIN also now. Now before a person applying for DIN, they are taking this kind of declaration only from the professional. That I really don't understand the logic. How could we know that I verified and satisfied myself that the identification particulars as filled in is proper? I don't know. But good thing is mole identification is not required here. if a mole identification is required, how could I get satisfied that it is there or not? So I will get slapped only by field, because I can't say that no. I have to declare that no, I have identified everything. Good thing it is not there. This information also should not go to the ministry. And procedure for signing the memorandum article, and this is the same method only what I told for company. The company, one extra requirement is that the person who is signing should be authorized by the board decision. As it is, we are doing all that in practice. If a company is promoting, without board decision, the regulatory authority is not registering a company. And the person so authorized, again the issue we were facing, everyone in the country were facing, that when I am signing as a representative of the company, and I should not sign as a second subscriber again. What happens? A company will authorize X as a representative to represent ABC company, to form a company. Okay, this X will sign as a representative of ABC Limited as a first subscriber. Then second subscriber, he will sign as X. So only one person will sign entire document. Now department earlier itself they were objecting, but certain cases they convinced and registered also. Now they came out with a clear this thing that there should be two different subscribers. Suppose one person is representing as X, that X cannot represent in his self capacity, own capacity, and somebody else alone can be another subscriber. This is a welcome provision only, because it clarifies many things now. And if subscriber is a LLP, again same method. However, in case of LLP, shall be signed by all partners. Here there is no concept of resolution. Here it should be resolution to be approved by all partners. Whatever they say, it's a resolution. Even you give a letter also, it's a resolution. There is no parameter or definition prescribed in the Partnership Act, how it is prescribed under the Companies Act, what is special resolution, what is ordinary, how it should be passed. Resolution is something we give, all partners sign and give is a resolution. The person who so authorized shall not at the same time be subscriber, same concept. If I represent LLP, I can't be a individual signatory. Yeah. Here's a big thing which I don't know, many would have, who started incorporated company, keeping a foreign national. In fact, if the subscriber is a foreign national, residing inside India and who visited India and intended to incorporate a company, then the method is same only, how he has to be witnessed by another person and all this name, all that what I said, no, all that name details to be given. Then the incorporation should be allowed only if he comes in a business visa. So employment visa, then it is not allowed. That's the thing that we need to understand. See, some foreign national comes down to India in employment visa on some employment, he can't incorporate a company. So that's what they indirectly mean to say, that you should have a valid business visa. And if subscriber is a foreign national residing outside India and living in the country, any and part of the Commonwealth countries. Suppose the person is residing in a Commonwealth countries, then it is sufficiently the document is attested by the notary public. The whole logic is very simple. There is a Hague Convention is there, where something signed in the country outside the India also party to the Hague Convention, where something signed outside the India can be accepted by Indian government for any registration purpose. This is not only for the company, but should be accepted by any statutory authority in India that's supposed to be signed as per the parameter given in the Hague Convention. In case of Commonwealth countries, in case of other countries which is part of the Hague Conventions. As per that, now the person residing in a country which belong to Commonwealth countries, it is sufficient he get a signature of notary public of that country and send the document here, then it will be accepted for registration. Same way, if the subscriber is a foreign national and living in a country which is party of Hague Convention, which I was telling, if that be the case, then it should be certified. That means the witness should be done by the notary public of that country and to duly apostilled. That concept is not there in India. There the concept is there. In those countries, there is a notary public is there, and apart from that, apostille is there. Like senior, junior. Like notary public is a junior in those countries, and apostille is like a senior fellow. And not only should be notarized, it should be notarized, should be apostilled also. That we are following even now also to register the companies, to foreign nationals. And next, the subscriber is a foreign national residing outside India, living in fact, you should know the distinction. Then only you know how to form a company with a foreign national, keeping foreign national. Subscriber is a foreign national residing outside India and living in a country outside the Commonwealth and which is not a party to Hague and Apostle Convention. ரெண்டுமே பார்ட்டி கிடையாது. Then subscriber signature and address on the memorandum proof shall be notarized by a notary of such country and that notary public shall be authenticated by a that country consular officer and diplomat. This is the additional requirement if they are not party to the Hague Convention and Apostle Convention. These are the parameter. If a foreign national starts a company, this is a signature requirement for incorporating a company. And provision relating to MOA, AOA. And now before I go into the basic thing that which in fact one question came to the previous speaker chairman that what are the things immediately I have done. Probably I can say a few things, even I need be I will send the details to you. What are the things immediately to be done? And we can't in fact if you say officially and formally what are the things to be done, in fact the entire things which is specified in 283 section has to be done immediately because all are applicable now. What I can say that that should be immediately done, but probably with respect to accounts